Advocate Mutlamunyane. Advocate Batohi, we thought that before you begin counsel, counsel from the NPA should, as and when it is necessary, she can sit next to you actually. Is it possible to have that chair being brought closer to her at the corner? If necessary, you can whisper to Ndatem Kabela. But feel free to sit there. And when it is necessary, Madam, you can go back to the junior counsel, but take that as your seat from now to make it easier for Advocate Batohi to page through her documents. And when you need to go back to the other side, feel free to do so.
Thank you, Chairperson.
You may proceed, Ndate Mutlamunyane.
Chair.
Thank you, Madam Chair. Yeah, I was getting to it.
Okay, sorry about
that. When we adjourned, Madam Ramakhaga wanted to ask a few questions for clarification to Advocate Batohi.
Good morning, Chair. I'm still of the intention to ask questions, and I will proceed to do so. Advocate Batohi, can you just advise as to why we were only getting annexures to Dr. Braff's report yesterday? Or is it annexures to Dr. Braff or whoever you think that supplementary documentation that we received?
Yes, thank you. Those are not annexes to Dr. Broughton's affidavit.
Yes.
Those are annexes to what has been referred to as the de Kock report.
Yes. Yeah.
Which is part of my affidavit.
Yeah, thank you for the correction. Why were we only getting those annexures yesterday?
The reason for that is that because of the volume of it, it was the de Kock report. If one reads the de Kock report, it's clear that they are annexures to the report. And it's also clear that those annexures are not attached to my affidavit. The reason why we didn't do it is because I think in my affidavit we refer to, I hope we do, or the de Kock report refers to the annexures, but I'm not sure whether in my affidavit we actually refer to where in the bundles they can be found. My understanding is if you look at my supplementary affidavit, some of the, and I'm speaking from memory because I'm not looking at it now, but some of the documents are documents that are in the bundles, and there's a reference to it. And some of them, thank you, and some of them, if you look at, in my affidavit, paragraph 13, as I explained yesterday, the first three annexures to Advocate de Kock's affidavit, well, not his affidavit, the panel report and opinion are in the bundles, the first three. And the remaining four are not contained in the bundles. It was only because of the voluminous nature that we did not attach it. And I would suppose because of the serious time constraints that we had in terms of trying to put my affidavit together. And that's the reason.
Yeah, I'm asking this because it is my understanding that when you read a document that refers to annexures, that document will only be complete when you also read the annexures.
That is correct.
So the proper thing to have been done would have been to avail those annexures simultaneously with the report.
Accepted, Chairperson.
Thank you. Now, on the balance of the your affidavit, are there still any outstanding annexures to the documents that support your affidavit? Or as far as you are aware, all documents have been availed?
I think we must check that, because some of the documents referred to in my affidavit, for example, Dr. Broughton's report and the annexures thereto, those annexures were certainly not attached to my affidavit because of the voluminous nature of it. But my understanding is that those have been uploaded and we can refer to them. What I propose through you, Chair, is that we do is go through my affidavit carefully and make sure that every document that is referred to either has an annexure attached to it, or there's a clear reference to where it can be found in the bundles, so that the panel can easily access the documents.
Yes, yeah, that is the exercise that ought to have been undertaken earlier, but I hope in my questioning it will not become necessary for other documents that are outside the record that we have, that would have to be brought in. Now, when do you say you formed an opinion that Advocate Chauke's conduct requires or necessitates the establishment of an inquiry?
As I mentioned, I had been considering this matter for a while, and I had been receiving opinions over a period of time. In fact, it spanned years from the first Nalane report opinion. I finally would have decided to refer it at the point I had considered the evidence in the Boyson matter and the evidence in the Nguni matter that had been placed before me. So after that, I made my final decision to refer it, and then I wrote to the minister.
Yeah, can you just give us an idea, when did you form the opinion, or when did you come to a conclusion that this matter or this conduct necessitates a recommendation for an inquiry to be held?
When I had looked at all the
Yes,
evidence.
the timeline, was it around February 2024, 2021, and so forth? That's what I'd like.
I think it would have been finally on the Boyson matter. I had made a decision after. Well, I'll look for the timelines, but just in terms of when it would have been, I was clear after I looked at Dr. Broughton's report. With regard to the Mgluli matter, I made the final decision after I looked at the evidence that was attached to the Hali and Wenzel. And we can look at opinion, and we can look at those to get dates. If you'd like me to do that now.
Yeah, it'll help. I don't want us to be going back again and forth. At least let's travel this path and, moving forward, and without having to time and again go back and check.
Certainly, I would appreciate that as well. So if we can we'll try to get the documents to make sure we have the timeline. Dr. Broughton's report is the date of that. If we can just look at the date of that, that will be the first thing. So the second report, and understand I'm giving an estimate of the timeline.
I understand well.
The second report of Dr. Broughton with all the annexures is dated the 21st of April 2023. I would have taken time to consider all of this, and it would have been, the decision would have been made sometime after this. When I did, before I got the opinion of, and I'm trying to get the timeline, maybe we'll get the opinion, if we can get the opinion of Advocate Hully and Wenzel, that will give me a sort of window period when I was considering these matters. That opinion is dated I do know that I certainly looked very carefully at all the evidence in the Broughton report. This document is dated the 10th of July. So it would have been sometime between the 21st of April and the 10th of July that I would have decided that I had sufficient evidence with regard to the Boyson matter to refer the matter.
And the Mdluli matter?
Yes, in a moment. Just want to make sure I make a note of these dates, so when I'm asked later, I'm not trying to understand what those dates were again. 21 August until 10 July. Okay, and the Mdluli matter, it would have been sometime after the 8th of, this is 8th of July? Sometime after the 10th of July, and the date on which I sent the referral to the minister, which is an attachment. I think it's in my bundle. I think it's SB10. I think it's SB10. SB10 is dated the 18th of August 2023. It's page 275, SB10, and the date of that is 18 August 2023.
Is 18 August 2023 the date on which you took the decision in respect of the Mdluli matter?
No, it's not. I didn't give a date. I said there's a window period. It will be after the 16th of July. No, it's not 16th, 10th of July. 10th of July 2023, when I got the Hully and Wenzel report. Between that date and the 18th of August 2023, when I forwarded the recommendation to the minister.
I beg your pardon. I think we're going to spend some time on three documents to get clarity on issues. And those will be the SB5, which is in pages 231 to 235. And then SB 5A, which is in pages 236 to 237, and then SB6, which is in pages 240 to 260. And LO1, which is in pages 30 to 119. Yes, I think that will be the main documents that I will seek clarity in respect of. But I will then start off with the SB5. SB5 makes a reference to a request for further information. You say it's headed request for further information relating to decisions made by you as the SDPP. Now, a request for further information supposes that there was information that had been received earlier, and this is a follow-up to request for further information. Now, what I would like to get from you is, when was the other information received by yourself or obtained by yourself? It may have been something that is lying in your records, or it may have been something that you actually sought for from someone.
So must I go through each one of those matters?
No. Yes, I'm asking as to, if you ask for further information, it means you have some other information that you could have possessed, either by virtue of being in the office, or you could have obtained from someone else. The first question is, the information that you already had, where did you get it from?
Okay, so I'll deal with each one of the matters. I did refer to it yesterday, but I'll deal with it again, each one. So the Boyson matter, we'll start off with that one.
Yes.
So with regard to the Boyson matter, there was a lot of information that I had. I had information, well, the Zondo Commission was in progress, and there was a lot of evidence that was tendered there. There were court decisions relating to the Gorvin judgment. And yeah, so there was all of that information that I had, which led me to, especially given the Gorvin judgment, to the point where, as the national director, I believed I couldn't bury my head in the sand. I needed to look into this, because there was clearly, having considered having all of this information, something that I needed to inquire into. So that's the Boyson matter.
So with regards to the Boyson matter, there was information in the records of the NPA, there was information out in the public in the form of the court judgments and court matters, and as well as the Zondo Commission. Right, thank you. And then with regard to the Mdluli charges?
And with regard to the Mdluli charges, they had been, at the time, I recall, there was, let me just say, talk in the NPA that these charges were that Richard Mbluli was being protected and he was not prosecuted in these matters. In fact, I do recall that I spoke to Zeiss van Zyl himself. We'd had one of the, I can't remember the date or even the year, but I'm thinking it was reasonably early in my term. It certainly would have been before this letter, I imagine. But it's part of the information. There was part of me getting the information, but I can't recall when I got this. But I know it was early in my term. I spoke to Zeiss van Zyl, and he told me he's the prosecutor.
SC?
That is correct. Advocate Zeiss van Zyl, he was a deputy prosecutor, deputy DPP in the Johannesburg office at the time, and was the lead prosecutor in the Richard Mbluli murder matter. I'm not sure what his role was in the others, but he might have been the lead prosecutor in all of the dockets. I did have a conversation with him, and he told me about the very strong case that they had in this Richard Mbluli murder case. You'll note from my letter, I say there, I have perused the NPS representation file to this matter. From a reading of the documentation contained in the file, I understand that Mbluli was arrested at the beginning of 2011, whereafter a decision was made to indict him and 3 others in the High Court for several charges, including murder, attempted murder, intimidation, kidnapping. The trial would have commenced on April 2012, but following a representation, you decided to withdraw charges and a formal inquest was held. I then
Advocate Batohi, I've read.
Okay, so that was the information that I also had.
Yeah, but what I was asking is, where do you get the that information? You have said there was talk in the NPA about the Mbluli case, and also that you spoke to Advocate van Zyl, who informed you that there was a strong case.
There was also
and who else or what else? Just give me the source, and you don't have to really read this. We have read this.
I'm reading it to refresh my memory so that I answer properly. So this is a long time ago. I am trying to refresh my memory, but also, so I had the NPS representation file as per paragraph 2.1. There were also the judgments in the Mbluli matter, the freedom under law case that I referred to in paragraph 2.2. From my recollection, that was the information on the Mbluli matter, but as I say, it may not be exhaustive.
And the information relating to the Karima Brown complaint?
That was a complaint from Ms. Brown herself, and I see that annexure was attached to my letter. I'm not sure if it's part of this bundle, but if not, is it? I think if we could check, if it is, let me check the index and see if it's in there. Oh yeah, it's 5C, SP 5C. So that was what triggered
the complaint that your office received from
correct.
Ms. Karima
That's correct.
Brown. Okay.
That was
the basis.
The information. Paragraph 4, as I'd indicated.
So just before you, now when you said you are asking for further information, is there any information that you had received other than the complaint?
Not that I can recall. I think it may have been in the public space. There may have been some media reports about it, if I recall, but I'm not sure.
You're not sure?
I'm not sure. I think it was in the public space.
Okay. But Advocate Chauke had not as yet furnished any information to you
Not that I'm
with
aware
regard
of.
to the current.
I can't recall, but I don't think so.
You don't think so?
I can't recall.
You can't recall. Thank you. And then
So I do feel like I'm being cross-examined, but I do. I can't recall.
Maybe
Sorry.
it does help,
Yes.
to express your view.
Thank
that
you.
feel like you are being cross-examined.
Yes.
And I think the other day the chairperson touched on that
Mhm.
to explain, and it's an explanation out of courtesy, because this inquiry is an inquiry of lawyers about lawyers. And I think all of us understand the term inquiry, and all of us understand the nature of the inquiry that we are now conducting.
That we do understand cross-examination
please,
as
ma'am,
well.
Please.
My apologies.
When I speak, please listen
Certainly.
and respond at your time.
Certainly.
So we understand, with an inquiry of this nature, part of what you do as the panel, you've got to make sure that you get all information so that when the time comes for you to write a report, you don't wish to call people that testified and to ask them for more information. And in this particular inquiry, you are the key witness. Any other witnesses that come after you are not really key. They may be important, but they are not key witnesses, because this inquiry has come into being because of your opinion. And your opinion was also based on other opinions that you obtained. But at the end of the day, it's about your opinion. And any other witnesses that may come here after you, they will not be able, or they may not be able to answer adequately about issues, especially with regard to motivation for the inquiry to be held and many other things. If they come here and corroborate, that's fine, that becomes a bonus. But at the end of the day, this matter should be traversed properly and adequately in respect of every witness, including yourself, and while mindful of the fact that you are the key witness, right? So we are inquiring. It is unlike in a court of law. In a criminal case, where there will be cross-examination. And I think as a seasoned lawyer, you understand, or generally, with the rules of cross-examination, that you ask leading questions. You're not asking for information. You are giving information when you cross-examine, and you expect responses. And that is not what is happening here. We are trying to get information. And I will proceed on that understanding. And I just want to make you understand that the panel is not confused about what is cross-examination and what is asking questions for clarity, what is asking questions in an inquisitorial environment, and what is leading evidence in chief. There's no confusion about the concepts. Now I will proceed.
May I comment on that?
Yes, you may.
Thank you. That's very helpful. I think it's important that we are all on the same page, because the chairperson did indicate to me in chambers as well that there's not going to be cross-examination. So I'm glad that we are all, there are differing views about it. I certainly have my own view about this, but I've got to be part of this process. I'm here to help the inquiry, and I will continue to answer the questions to the best of my ability. I do want to, in respect of me being the key witness, of course, I agree it's an important witness. My views on things that happened prior to me taking office, of course, important. But all of that other evidence that is being presented outside of my views on this is the hard evidence in this matter, which in my view is, I'm not saying my view is not important, it's critical, because as you say correctly, I referred the matter having a reasonable belief that this matter needed to be inquired into. And this is the inquiry. And my evidence is, in fact, in many instances, it's hearsay, and there will be other evidence by witnesses, documents, etc., that will speak for itself. So I wanted to make that point. Thank you.
Might I take this opportunity to clarify your statement as you answer Me Ramakhacha, that I made it clear in chambers that you will not be cross-examined. Did I understand you to say that?
That is correct, Chairperson.
It is important to put context to that question, to that answer, rather, and place that correctly on record, that it is not correct that I said that you will not be cross-examined. You know why I'm saying that? That following the parties' submissions or memoranda requesting that this inquiry should begin in February 2026, we considered it appropriate to call you as the head of the NPA and caution that it cannot be that your team, including the evidence leaders, or the view that we should begin this inquiry even 4 months later than the date that has been allocated to this inquiry, correct?
That is correct. I, in fact, agreed with you.
You indeed agreed. It was in that spirit that we considered appropriate to call you as the head of the NPA, so that you could sound a caution to your team to do things right. Because at the end of the day, the buck stops with you, correct?
That is correct, as the head of the NPA.
And we made it clear to you that this inquiry will not begin in February 2026, as was requested by the parties, precisely because we believed that when the complaint or the referral was made to the president, the NPA was or ought to have been ready to kickstart with the inquiry. Correct?
That was indeed your view, Chairperson.
And we formed the view that although the NPA is dragging its feet in providing information, we will begin to hear or to proceed with this matter on the 17th of November. Is that correct?
Chairperson, you did mention that. And I think in the context of our conversation, I explained to you that the NPA was really trying hard, given the volume of documents, to get things together.
And that meeting took place a day after I had called you telephonically, requesting you to attend the meeting. And during our discussion, you mentioned that you wouldn't want to be cross-examined.
Chairperson, that was in the course of our meeting when we met at your office. I said to you that I wasn't even sure that I was going to be testifying in this matter. And you expressed the view that it would be important that I do testify. And I agreed that I do. And I said to her, as I recall saying something along the lines that, yeah, you know, cross-examination is something that you don't look forward to. I certainly wouldn't look forward to it. And in that context, I agree. We talked about cross-examination, and the judge then made certain comments.
I'm referring to my telephonic discussion with you when I called to request you to attend a meeting at the chambers. Do you recall?
I do recall the conversation, Chairperson.
And during that discussion, you expressed the view that you wouldn't be keen to be cross-examined, and I said to you, we need not talk about that. We will have a discussion the following day.
Chairperson, I can't recall, but I don't doubt it. I have absolutely, I agree that if that's what you say, that's what happened. I know we talked about it the next day.
And more particularly, you expressed the view that you wouldn't want to be cross-examined by advocating Nkabinde, and I cautioned you that let us not discuss this matter on the phone. Let us have a meeting with you.
You did indeed caution me and said we should not discuss it on the phone and we should have a meeting the next day.
Now, at this meeting, in respect of which we wanted to discuss with you as the head of the NPA about the starting date of the inquiry, we clearly said to you that you will be the first witness to testify because you are the complainant who should set the tone of the inquiry. Is my recollection correct?
You did indeed say that, Chairperson.
And at what stage did I express a view that you would not be cross-examined?
During that meeting, Chairperson, my recollection is that I did mention the issue of cross-examination at that point, and that you mentioned that it will be questioning, but no cross-examination. That's my recollection, because it is an inquiry.
You see, Counsel, it is very important not to misrepresent facts to anyone, especially when you impute information to any presiding officer.
I agree with that, Chairperson.
It will be totally unacceptable for you to impute wrong information about me or about any of my colleagues sitting as panel members. I'm going to park it there and close by saying, in any event, it will be totally uncalled for to even discuss issues relating to whether you will be cross-examined or not when there is a litigant against whom you have made allegations. Advocate Chauke is represented, and there is no doubt that you will be cross-examined. And I'm sure you understand that.
I accept that I will be. I have no doubt about that either.
I'll leave it there and ask my sister to take it up if she wants to do so.
Just to add, and I'm going to try and quote you the way you put it. When you raised the issue of cross-examination, I remember saying, are you scared of cross-examination? And you said, no, I'm not scared to be cross-examined because I attend the Justice Portfolio Committee where I get cross-examined all the time. Do you still remember that?
I do.
So you accept that there was never a time when you were promised that you will never be cross-examined, because that never featured in our meeting with you.
Your comments are noted, Chairperson.
Pardon?
I say I note the comments.
I beg your pardon?
I note the comments.
You know the comment.
I do. Thank you.
Might I caution counsel that all of us are lawyers here. You are a lawyer. The litigant is a lawyer. Advocate Chowk is a lawyer. The team, we are all lawyers. We
That's correct,
understand
Chairperson.
basic principles of conducting disciplinary inquiries. And it is important that we take one another into each other's confidence, because we are here searching for the truth. And it will be totally improper for anyone's name to be dragged into this record, basically on any proposition or suggestion that we have misconducted ourselves. Because if you put a statement to the effect that I told you something that is incorrect, it's putting me in a very bad light. It is for that reason that I placed this context on record, so that anyone who reads this record at a later stage understands why a discussion was held and why you are incorrect to suggest that I told you that you will not be cross-examined.
Chairperson, if I may, I certainly did not intend to suggest that the chairperson had acted improperly in any way at all. It was my understanding, and so I really apologize if that's the way it came across, but it was certainly not my intention to create that impression that there was anything improper that was said to me during that conversation at all.
The question is whether that was said or not.
It was my understanding, in fact, precisely in the context of what Madam Baloy Mera mentioned, that we did speak about cross-examination, and I did indeed say that. That was my understanding. It could have been a mistaken one, but that was my understanding.
Yes, thank you.
Thank you, Chair. Yeah, I had asked you about Ms. Karima Brown. You had indicated that you had received a complaint. Right?
That is correct.
And now let's proceed to the next matter, is the matter of Brian Hlongwa. Remember that the question that I'm still asking is about further information
I do.
requested.
So Brian
It's
Hlongwa matter.
about further information
Correct.
requested.
So the Brian
So, it is not apparent from paragraph 4 as to where you have received the information from. I may be wrong, because when I read the third sentence, it says the DNDPP NPS has requested you to provide reasons for the delay.
Sorry, I'm just trying to get back to the page.
In the matter, it's page 234, SB 5234.
Yes, I'm there.
The DNDPP NPS has requested you to provide reasons for the delay in the matter, and have been placed in possession of same. So when you say that I have been placed in possession of same, what are you talking about? Is it about the request by the NPS, or is it about any other information that Advocate Chauke could have provided or had provided by them?
So I'm going to try to the best of my ability recall the events prior to that. I have testified here before that after I took office, General Libya mentioned this matter to me and expressed his concern that this matter had not, in fact, I can't recall whether it had been withdrawn or they were about to arrest Brian Shlongwa and they were stopped from arresting him. I can't remember the details, but his concern was that it was now about 7 years later and the matter had not been enrolled. As a result of that information, I discussed it with Advocate de Kock, and being the deputy in charge of the NPS, on the basis of this, and I'm trying to refresh my memory, what would likely have happened is Advocate de Kock would have sent a letter to Advocate Chauke and asked him for, well, sent a letter in response, and Advocate Chauke would have responded to that. That's what my note here says, and I'm giving him the opportunity to add anything further.
Yeah, you know the institution that we are talking about here, it's an institution that I believe is an institution of record. And it will help, you know, it's to try and, I don't know, when I say remember, I can't say you can only remember to an extent possible within your capacity. But at the same time, where you are raising issues about conduct, it helps to get the records. Did you look at the records that pertain to the matter of State versus Brian Hlongwa, or did you then get information, it would appear, unless you indicate otherwise, in passing, from General Libya and Advocate de Kock? And just to avoid giving you a compound question, I must break it into pieces. Firstly, let's talk about General Libya. Did General Libya present a formal documentation wherein wherein he was briefing you about the matter, bringing his concerns to your attention so that you can deal with the matter accordingly? Or how did he, and I'm still just confining you to General Libya, then we'll go to the next one.
With regard to General Libya, I cannot recall him sending a formal letter to me, but it was certainly not a conversation in passing. I had a meeting with him, my recollection, and it wouldn't have been a meeting about this particular matter. It would have been a meeting about other things. He's an important stakeholder. He was the head of the Hawks at the time, the DPCI. And of course, you have meetings with your partners in the system. And it was during one of these meetings that he expressed very serious concerns about this matter. That my recollection of this conversation was that it had been, I'm repeating what I said. So it had either been enrolled and withdrawn, I don't recall, or whether they were about to arrest Mr. Shlongwa when they were stopped from doing so by the DPP in Johannesburg. But he was very concerned that the matter had not been re-enrolled after that, because their understanding was that it will be. And I think there was what Advocate Chauke mentioned to me at a later stage, there was a possibility of racketeering charges. But that was not discussed in the meeting with General Libya. All he did was express concerns to me about the fact that a number of years had passed and the matter had not been re-enrolled.
you had a formal relationship with General Libya.
I'm not sure what you mean by a formal relationship.
Formal relationship as a stakeholder. You said he was a stakeholder, and I think it's common knowledge that he must have been a stakeholder there. He comes, he talks about something, serious matters, or a serious matter which is not getting attention and so forth. That comes through to me like it's a casual reporting. Like you say, there was no meeting about this. You had another meeting, you were at another meeting, then he tells you that there is this matter that is very serious, that is not receiving attention. And now, because it was not a meeting about this matter, we are likely not to get the minutes of that meeting or of that discussion. But at least, I'm sure, if he was serious and the matter was serious and it's about the concern, about the interest of the administration of justice, he could not have been that casual. I want to believe that he must have communicated with you in writing. He did not.
I'm not sure why the honorable panel member doesn't accept that it could have been something that was given to me during a conversation, because we're not just stakeholders, we are critical partners. We work together very closely on a range of matters and cases. And during one of my meetings, he mentioned this to me as a very serious concern that he had. I don't recall him sending anything to me in writing, but receiving that as a national director, I need to take it seriously. And I did. And from what I read here, because I'm trying to cast my mind back a number of years, Advocate de Kock or someone from NPS, I'm not sure if he was there at the time, because he joined the NPS in 2021, I think. So I'm not sure when this went to him. But there was a letter written to Advocate Chauke, and he was asked to provide reasons for the delay, because as I said, Advocate Chauke, General Libya was concerned that there were a number of years and the matter had not been enrolled. So in my view, that was the proper thing for me to do in the circumstances.
Yeah, well, I've noted the many. I don't remember. I can't recall. We spoke. It's fine. So the second line is saying the NDPP has requested you to provide reasons for the delay. Where can we find copy of this request that was made to Advocate Chauke about the matter?
We will check the NPS records.
Okay, so it will be provided.
Yes.
Of course. Yeah, the problem, I had hoped that today we would sail without the possibility of having to go back. We don't know what the document will be having. It may even then become necessary to go back. But then we'll see as it comes as to whether it's necessary or not. Let's go to the last matter.
Might I, if the document that is to be provided, shouldn't it be part of the list of the exhibits, Advocate Muhlamunyane? To the extent it may be necessary. Paragraph 4.1.
I see that, Madam Chair. It will be made part of the exhibits.
Advocate Batohi
If it is,
undertakes that it will be provided. That request.
Which is supposedly in writing.
Supposedly in writing.
Indeed.
Please make a note of that, Madam Junior, and include it in the bundle of the index for the exhibits.
And it will be accordingly marked, Madam Chair, as an exhibit.
Yes. Yeah. Thank you. Proceed, colleague.
The last one is the matter of State versus Duduzane Zuma. Again, in respect of that matter, talking about the question of your source of information, where you requested him then to avail further information. You indicate that you have perused the representations. Please, it's SB 5234.
Yes, I'm there.
Yeah.
Thank you.
Oh, are you there? Okay, sorry. I'm sorry about that because I did not mention the page number again. I've perused the representation file of office, but you are kindly requested to provide me with a further copy of your office file in which the record of the original decision not to prosecute is recorded, as well as copy of the related office files. Now here it is clear from what you are saying that you have perused some documents and now you are giving him an option, or you are inviting him to provide further information if he so wishes. Now, this document that you had, the representation that you had perused, have they been availed to the inquiry?
Not that I'm aware of. I haven't
Yes.
even perused it since then. We certainly can make that available.
Yes, it will help to make them available, because in the beginning we can see that, there are the matters, right? I don't know whether there were even more than that, but we see that this letter of the 13th is referring to these 5 matters. And much as the inquiry now is proceeding in respect of the 2 matters, it does help to look at the matter holistically when we deal with the report, right? So that is another document that will be available.
It will be
The
more than a
representations.
document. My understanding
Yeah.
is that it's a file, because
Yes.
once there's a representation file
Yeah,
that
that's
is
fine.
sent. It's opened in the NPS.
Yeah.
So we'll certainly make available that file.
Okay.
And
No,
if I
yeah, that's fine.
if
That's
I may
okay.
confirm that with regard to that particular matter, Advocate Abrams overturned Advocate Chauke's decision and decided to prosecute in that matter.
Yeah, we'll come to talk about that. The focus of the questions that I've been asking now was just about
Sure.
the source and why you are asking for further information. Now, the issues about the matters will receive attention. I think we can then proceed to deal with now those matters in particular. And I think when we deal with them, I'll be maybe even cross-referring where necessary, right? Cross-referring between the SB5 and the SB6. Right. Now, let's look at the Boysen's matter. I've said SB6 pages 244 to 254. Yeah?
Sorry, what's the page numbers again?
SB6 244 to 254. Right? What I'd like to draw your attention to, or the inquiry's attention to, in respect of that matter, it's 244. At paragraph SB5, I'll start with your letter, that letter of the 13th. I think it should just be recorded that is the letter of the 13th day of May to Advocate Chauke. Then the SB6 is the reply to that letter. That reply of the 28th from Advocate Chauke to your good self.
That's correct.
All right. Now, in your letter of the 13th, at SB 5232, paragraph 1.2, the apparent accusation against Advocate Chauke is he's supporting a decision to prosecute. Do you see that?
Sorry, where is...
Paragraph 1.2.
Ah, yes, I see that.
1.2, and the conduct complained of there is supporting the decision to prosecute in this matter. I'll read that subparagraph 2 into the record. SB 5232, paragraph 1.2. As the lead prosecutor, explain why your reasons were for supporting the decision of the prosecutor in this matter. So in that one is the question of him supporting the prosecution.
That's correct.
Yes. And then a question that arises from that is, whose decision is he accused of supporting?
It's not a particular person, but it is the decision to prefer racketeering charges against General Boyson.
Yeah. The sentence says supporting. So when you support, you would be supporting something from someone, unless my understanding is wrong. It says, as the lead prosecutor, explain what your reasons were for supporting the decision to prosecute in this matter. Maybe let me hear from you. I think you can better interpret that. I may be misinterpreting what you're saying there. Supporting.
So what I'm saying is that there was a decision to prosecute General Boyson and on racketeering charges. And there would have been various decisions made at different stages in that process by different people. So you have a team of prosecutors who would be looking at the case. They may decide there's sufficient evidence, and they make a decision then to refer the matter to the DPP in charge at the time, who was General Advocate Chauke. He then makes a decision to support that decision, and then to support a recommendation, having satisfied himself, to the national director. So what I was saying here is just saying in one line to Advocate Chauke to explain his reasons for supporting this decision, and being a part of that decision to prosecute General Boyson.
Yeah, I beg your pardon. We should get the automated ones where you control from that side. Okay, this was not on record. I'll just read it again into record. Paragraph 1.3 reads, please also advise on your views on the legal position regarding the legality of you leading the prosecution in another province, as well as that of the rest of the team. Now, the first question that I will ask is, the two paragraphs, subparagraph 2 and subparagraph 3, do they relate to the same matter?
That is correct. They do.
Where in paragraph 2 he's referred to as the lead prosecutor.
Pardon me?
Yeah, where in subparagraph 1.2 he's referred to as the lead prosecutor.
That is correct.
And in paragraph 1.3, is it that one that relates to the Mlochwa matter, the Advocate Mlochwa's jurisdiction, the KZN?
It's the KZN jurisdiction. That's correct. It was partly Advocate Mlochwa and partly Advocate Noko.
Okay. I think the issue of the Katomena has been addressed almost adequately, and maybe let me leave it there, except for one thing that has caught my eye, and it is in LO1. Yeah. Before I take you to LO1, I think in the process of the presentation of evidence, there is a moment at some point where there was an indication that the suspects or accused, whatever their status, in the Katomena case, had a close working relationship with the DPP of KZN. Do you remember that, or don't you remember that?
I recall something that either Advocate Jiba or Advocate Chauke mentioned in one of the documents.
And that suggestion that there was this close working relationship between the KZN DPP and the Katomena suspects or accused, whatever their status. Would you agree with that suggestion that there was a close relationship between them?
I can't agree with that because I was not there at the time, but my recollection also is that what Advocate Jiba and Advocate Chauke, one of them or both of them, I'm not sure, was saying was that there was a close relationship between these accused or suspects in the Katomena matter, who were police officers, and the prosecutors. I don't think they would mention the DPP.
Okay, I think that will be verified from the record. Thank you. Do you agree that Section 22(3) of the NPA Act does, in interpreting that provision, where the should I proceed? Have you found the
Yes, I have.
provision?
Thank you.
Where the NDPP is of the view that it would be looking at the relationship between the suspects or the accused with the prosecutors or even with the DPP of the jurisdiction where the offense has taken place, can, if he or she finds that it would be in the best interest of the administration of justice to bar the DPP of that jurisdiction that is affected from prosecuting the matter on the basis that the matter, it would not be in the interest of justice to allow her or him to prosecute the matter.
So on this scenario that you sketch, because it's still not established as a fact whether the prosecutors were compromised or not, or whether the DPP was compromised or not, and Advocate Malochwa can talk to that. But on the scenario that you sketch, there is a provision. What would happen in those circumstances if the national director is of the view that the DPP is compromised with regard to a particular case? Am I understanding correctly?
Just interrupt you. I think you understood the question. I've not even asked it in the context of this case or, related to the facts. I've just said, looking at that provision in particular, do you agree or not that it does allow for the NDPP to bar the DPP in whose jurisdiction an offense may have taken place, to bar that DPP from prosecuting on the basis that there is this relationship which is likely to affect or to be seen to affect the exercise of the prosecutor's powers? Exactly.
I understand the question well.
Yeah.
In those circumstances, in order to ensure that the DPP does not oversee that matter, has no legal authority over the matter, what the national director would be required to do in order to give effect to what you term as barring the DPP from dealing with that matter would be to remove that matter from the jurisdiction of the DPP KZN and place that matter in the jurisdiction of another DPP who will then have the legal authority to deal with that matter in his or her jurisdiction.
So you say,
Pardon, let me just get clarity on that. Will that happen, Advocate Batohi, even if an offense or offenses were committed far from the jurisdiction of this DPP who is now appointed to deal with the matter? I'm just thinking of a scenario where, for example, number of transgressions or offenses, serious offenses, are perpetrated in KZN. And there are allegations that the DPP KZN is or may be compromised. And the NDPP then decides to move the dockets from the jurisdiction within which these offenses happened, in this scenario, KZN, and move these cases to Johannesburg so that they may be prosecuted by the Johannesburg or South Gauteng. I'm just giving an example.
Sure.
DPP. Does that happen at the practical level?
Chairperson, there will be no other way of dealing with it. If that happens, that will be the only option, even though it will cause inconvenience for witnesses. But the DPP, if the national director is of the view that the DPP is compromised, as the scenario that has been sketched, there will be no other option, because there's nothing that empowers, it would go against the constitutional framework to give power to another DPP to be the DPP in charge of a matter in another jurisdiction. So in as much as it would cause inconvenience, there would be nothing else to do. Alternatively, if the DPP is compromised, you would look at whether you need to remove the DPP, but it will have to be removed. The case will have to be transferred from the jurisdiction of KZN or any, whichever it is, into another jurisdiction, and arrangements will have to be made to deal with it.
I do understand the constitutional imperatives, but the Constitution is a document that must be given life. Now, if in the administration of justice, you cannot prosecute a case within the area of jurisdiction or cases, for example, in the Katomena matter, where a lot of killings happened in KZN, and the suspects are also from KZN, meaning that all witnesses involved will be in KZN.
Mm-hmm.
Will it be against the letter and spirit of the Constitution for the NDPP to exercise his or her control and direction in terms of the law,
Mm-hmm.
to delegate a DPP from, say, Northwest to go and prosecute in KZN in a matter or matters in which he or she is not compromised?
Chairperson, in my view, it would be against the constitutional framework to give a DPP from another division any powers, prosecutorial powers, in respect of a case that is not in his or her jurisdiction.
Just thinking about the interest of justice.
Sure.
Public interest, interest of justice, the costs of having to move accused people to Gauteng or to Northwest, witnesses and people who have lost families to be relocated to Johannesburg for the case to be heard in Johannesburg, purely because the Constitution says you cannot delegate. I'm not sure whether it says that, but purely, let's even assume the Constitution is phrased in such a manner that it negates one DPP from one jurisdiction to go and perform a prosecutorial function in another.
Mm-hmm.
But looking at the broader picture, given the interest of justice, public interest, and all other aspects that I've mentioned, will that be in the interest of justice? To move that case, those cases, to Northwest or to Johannesburg, instead of moving one prosecutor to go to Durban or KZN and deal with those matters? Is that, will that be in the interest of justice?
Chairperson, as I've said previously, I'm not a constitutional law or an administrative law expert.
No, I beg your pardon, madam. I'm just talking at a practical level. I mean, I'm not taking the law here. Just common logic. Simple logic.
With all due respect, Chairperson, it is about a constitutional framework. That is my understanding.
No, I'm saying put the constitution aside. Let us just talk about the day-to-day functioning. That if you were to decide as the head who has control over the administration of justice, and you are seized with such a matters, and it appears that, and I'm not talking expediency, I'm just looking at the broader pictures of circumstances that may necessitate a delegation for someone to go outside his jurisdiction and perform that prosecutorial function. Will that be something that, apart from the Constitution, cannot be done? You wouldn't be having any discretion as an NDPP to say, given these circumstances, I will delegate Advocate X to go and prosecute in the jurisdiction outside his or hers?
Thank you, Chairperson. Chairperson, so I have to understand in your scenario whether you are speaking about a prosecutor, Advocate X, or a DPP exercising jurisdiction. It's an important distinction. And initially, the question related to the DPP, but what I'm hearing the Chairperson now speak about is someone outside the jurisdiction. So I need clarity on that.
Pardon, I think let's confide it to DPP.
Thank you, Chairperson. So in that scenario, in my view, the DPP of another division cannot exercise powers in a jurisdiction outside that which he or she has been appointed to. And so a national director cannot ask a DPP to exercise these powers in an area outside of his or her jurisdiction.
Thank you.
Before we go there, the question is, when did you brief Advocate Nalani? His opinion is dated the 19th of October 2021. That is the date on his brief.
It's at 19 October 2021.
Yes, yeah. Yes, the question is, when did you brief him? Yeah.
Chairperson, we've been trying to get that information. We did get one letter that was written to him from my office, not from me, because the procedure to brief counsel is generally that the Legal Affairs Division, together with our procurement section, finance, would send the brief out to counsel. So we've got a letter, but I've still asked them, because the letter is just a one-pager, and we'll make it available, but I've asked them to get the actual brief that was sent to him, because this letter is not clear, in my view, about what exactly he's being briefed to do. Do we have that letter? Make some copies. So we did have copies of that letter. Council, I'm not sure if we've got that available, but as I said, I'm still trying to get the brief, because I think there should have been more information, in my view, that went to him. And this document doesn't seem to be the full brief or a letter that contains, in my view, sufficient information. But I don't know if it was the only thing that went to him.
But
we are
can
checking.
Can you assist about the date? If
Yes.
not the precise date,
What's the
then
date?
the estimated date around which period was
I don't see
briefed?
oh, there she is. She's there. I think my colleagues are trying to find the letter. We did have a copy of it, so if we can get that and get the date, will be helpful. Oh, we don't have it here. I have the electronic version, so in the interest of time, we will make copies. If I may, Chairperson, indicate
If you
it's the
have the
21st
answer.
of July, 2021. It's a letter addressed to, it's from the State Attorney's Office. Oh no, it's addressed to the State Attorney. It's from the administration section in the NPA. And it is a letter that's sent to Advocate Nolane, informing him that his appointment has been approved to provide the NPA with an opinion on the implications and decisions taken by Advocate Chauke, the DPP South Gauteng. Please therefore, sorry, this is not to Advocate Nalane, it's to the State Attorney. Please therefore issue a brief to Senior Counsel. Such a brief should include assistance required in respect of both legal advice and consultation, any associated disbursements, they go on to talk about that. And it's dated 21st July, 2021. And it's signed by the Acting Chief Director of Financial Management in the NPA.
Would it be safe to say he was briefed during or around that period, the 21st day of July?
I would think it would be safe to say so on the basis of this.
Okay. And is there a way of ascertaining the precise date?
We are certainly trying.
Okay. I'm sure you'll find it. Now, let's go back. So it's around July 2021.
Yes, late July 2021.
I will not dwell much. I've already said on the Boysen's matter. Now on the Mdluli matter, SB5, that is your letter, page 232. 232. Paragraph 2.1, which reads, I have perused the NPS representations file relating to this matter. From a reading of the documentation contained in the file, I understand that Mdluli was arrested in the beginning of 2011, where after a decision was made to indict him and 3 others in the High Court for several charges, including murder, attempted murder, intimidation, kidnapping. The trial would have commenced in April 2012, but following representations, you decided to withdraw the charges and a formal inquest was held. Now, the representations, the NPAS representations file, in fact, those representations, they are in the NPS file.
That's
right. And where do we find them in our bundles?
They're not in the bundles.
They are not in the bundles.
We will make arrangements to get that file.
Okay. So then that increases the list of exhibits. It will be noted. I beg your pardon?
Say the team are making a note and we'll
Yes,
definitely
yeah,
get that.
that's fine. Right. Now I will proceed to the matter of Karima Brown. Right? Miss Karima Brown is the complainant. You invited Advocate Chauke to give you further information or to comment, and his reply is in SB6 pages 255 to 256, as I have said, but in particular at paragraph 58 to 59. Are you there? The
Yes, I
paragraph
am.
58 is in page 255.
Mm-hmm.
Is that SB6?
SB6, yes, SB6, page 255. The paragraphs that I will read into the record is paragraph 58 and 59. And that was the complaint where Miss Karima Brown had complained to the NPA about the conduct of of Advocate Chauke, and Advocate Chauke had reported her to the Broadcasting Complaint Commission of South Africa,
Mm-hmm.
Where he was not satisfied with the decision, then he appealed, and his appeal was successful, according to this record. It reads, I subsequently reported her conduct to the Broadcasting Complaint Commission of South Africa. A copy of my complaint is annexed here too as Annexure AC1. Where do I find that AC1, the complaint of Advocate Chauke against Miss Karima Brown's conduct?
It would have been attached to his letter. We'll check the files and get that. Is it attached?
Yeah.
We'll get that document.
You'll get that document. It's AC1.
Mm-hmm.
At the BCCSA hearing, the issue of her being intimidated by me arose, and the commission found that there was no intimidation at all. The BCCSA wrongly made a finding that there was no breach of the code and dismissed the complaint. So the BCCSA found that there was no intimidation that arose from Advocate Chauke, and further, then it made a finding that, well, notwithstanding there is no breach, there was no breach of the code. Now, he appealed this decision, and he was successful in his appeal according to this document. And the finding of the appeals committee or the appeals panel, whatever the name is, was made on the 10th day of May 2021. The appeal board ruled in his favor, and attached is copy of the ruling. That ruling is not in the record. Can we also have copy of that ruling? It's described as AC2 in page 256.
Certainly.
Right.
Yesterday we said that she cannot go to the Morabi's issues, all those issues that do not fall within the aspects of the complaint. I'm not sure, but they went in the opposite. The issues of Brown, etc. If they are relevant, that they've taken there.
Yeah.
Where you going to?
Right. Thank you. Thank you. And you say it will be made available. Right.
I do.
Thank you. And now let us go to maybe let me finish of this, because the next one will be Brian Hlongwa. And then it will be Duduzani, and then the briefing of Advocate Nalani. Let's go directly to the Advocate Nalani's opinion. As I mentioned, I've not only confined these questions to the matters of Nguli and Boyces, and I have done so because I am looking at the opinion or the brief, in fact. I think the brief, much as we do not have the brief, and that opinion of Advocate Nalani is found in LO1 from pages 30. LO00030. Are you there?
030, yes.
Yes.
That's
Yeah.
correct.
Yes. And now I'd like you to turn to page 00034. Right? This introduction, or rather, the opinion of Advocate Nalani in itself, it's a fair reflection of the brief that was given to him. Is that correct?
It looks like it, certainly.
It looks like it.
Yes, he's been requested to advise that, and I mean it speaks for itself.
Okay, so you confirm that it is
Yes,
correct.
I do.
Right. Now, when one looks at the paragraph 3 on page 34, it says, I'm requested to advise whether Advocate Chauke is guilty of any misconduct, has failed to adhere to the prosecution policy, or whether he is, on account of his incapacity to carry out his duties of office efficiently, not a proper person to hold the office of Director of Public.
I think it should read fit and proper. There might be a mistake there. Fit and proper.
Yeah. And in paragraph 4, he says, if warranted, I am briefed to draft the necessary submission to the President, advising on the prospect of success in such inquiry into fitness to hold office. So is it correct to understand this brief to be a brief that is requesting for an opinion on the conduct of Advocate Chauke, and also a brief that in the event that the opinion would be that the inquiry would be justified, then he should also draft the necessary submissions to the President, advising on the prospect of success in such an inquiry into fitness to hold office.
So you are correct. What would happen in these circumstances is that when we brief counsel, it's not uncommon for us to make sure the brief includes a second step, so that there's no need to go and draft another brief and go through the whole procurement process again, that the office would add that second step in case it's necessary to avoid those logistical issues. That is correct.
Yeah. what is correct, or what I'm actually highlighting, is the fact that this brief is a brief about opining on the conduct of Advocate Chauke, and the second leg being to draft the representation's letter to the president should he opine accordingly.
It's not his decision to draft the letter should he opine that. It would be our decision in the event that I am of the view that the letter needs to be drafted, having considered the matter, then we would request him to do that.
Right. So he would be, in the event, had you decided upon receipt of his opinion, had you decided to refer the matter to the president, then he would also have been briefed to draw the letter of representations.
That was always, yes, it's a possibility. We add it, as I say, we add it in briefs. It doesn't mean you have to go back to that council. You could decide you want another council, but it is included in that to avoid unnecessary procurement if that stage is reached.
Yes, I do not have briefing a different council in mind when I ask this question. Now, let me take you to page 37 of that opinion. Now, paragraph 14 says the decisions concerned involve the following matters: General Boyson's prosecution, Mdluli murder charges. How many charges were involved? Murder charges were involved here.
My understanding, it was one murder charge. In fact, it was one murder charge and an attempted murder and other charges.
It was one murder.
It was one.
And complained by the late Miss Karima Brown, the state versus Brian Hlongwa, and the state versus D. Zuma. Now, I will not dwell or even deal with it at all. That one of General Boyson, that one of Mr. Mdluli or General Mdluli. With regards to the conduct of Advocate Chauke in respect of the complaint by Ms. Karima Brown, it is correct from the evidence that has just been laid that as at the 10th day of May 2021, the appeals board or appeals committee of the broadcasting complaints had cleared Mr. Advocate Chauke of misconduct, and you were in possession of that information then. The clearing, the ruling was attached to the reply that was sent to you on the 28th day of April. And it is also correct that notwithstanding that he had been cleared and his complaint of breach of the code had also been confirmed, you nevertheless sent this complaint as part of the brief to Advocate Nalani in or around July, about 2 months later. Is that the case?
That is correct.
And the matter of State versus Brian Hlongwa, that one too,
Sorry, the matter of?
State versus Brian Hlongwa, on page 37. We are in page 37.
Mhm.
Advocate Chauke had already replied to your inquiry on the 28th day of May regarding that, and you nevertheless still included it in the
Mhm.
brief for opinion from Advocate Nalani SC.
Mhm.
That is correct?
That's correct.
Yes, thank you. It will help just to confirm on record. And that was 2 months after receipt of the reply from Advocate Chauke.
That is correct. I take it if you're going to draw inferences from this, you will ask me further questions. Whether I, in the time,
Asking which question are you answering?
oh no, that was just a comment.
Oh, okay. Thank you. And paragraph 14.5 is the case of State versus D. Zuma. And it is correct that by this time, this case had been finalized. Is it correct?
I'm not sure that it was finalized, but I think the deep, well, not the, I know that the previous national director had decided to prosecute, had
Okay.
overturned Advocate Chauke's decision.
Yeah, maybe, yeah. Let me just give you the brief background. And that brief background to that matter appears on Advocate Chauke's reply to your letter. Ne? And that reply appears in SB 6 257 to 259. SB 257. In fact, to be specific, yes, it's 257 to 259. Okay. Now, just the background as appears here. The background of the matter is that I'll start off at paragraph 64. This case was referred from Randbeck to the Director of Public Prosecutions, and the matter was handled by Advocate Galeka and Advocate Mapiri as senior state advocate.
May I clarify, my sister, you're referring to the Hlongwa matter?
I am sorry about that. I'm on SB 6257. It is the Duzani Zuma matter. SB 6257.
Yes, thank you.
And I'll start with paragraph 64, which reads, That was the response of Advocate Chauke. The matter came through to this office from the senior prosecutor of Randburg, Mr. Yusuf Baba. The work allocator at the time, Advocate Fanzil SC, allocated this matter to Advocate Mapiri, a senior state advocate, and Advocate Koleka Galeka, a deputy at the time. I think she's the current public protector, to be checked of same. On 9th July 2014, the latter finalized, that is Advocate Galeka finalized a decision and decided that an inquest should be held. She informed me of such a decision. And paragraph 65 confirms that the matter was then returned from the inquest, and it was then sent for consideration on whether to prosecute or not. And they both, Advocate Galeka and Advocate Godwana, considered the matter and then decided to decline to prosecute. Paragraph 66, Advocate Chauke looked at the docket and satisfied himself that the matter, much as there was a prima facie case, but there was no winnable case, and as a result, he says, I was satisfied that there were no reasonable prospects of successful prosecution in the matter, and accordingly endorsed the decision not to prosecute. So he was endorsing the decision of Advocate Galeka and Ngodwana. Then in paragraph 67, Advocate Sean, Advocate Abrahams and Nzinyat then reviewed Advocate Chauke's decision and instituted the proceedings. And the matter then went to court, and the case was then finalized with an acquittal. Now, this happened. The review of Advocate Chauke's decision was done in 2017, and it would help to get information as to when, in actual fact, I enclose here with, in paragraph 69, Advocate Chauke is enclosing an explanatory note from the logistic manager because certain information could not be obtained because of the fact that according to policy, I think it's the NPA policy, certain documents get destroyed after a particular period. So we would like to get a copy of that explanatory note from the NPS, AC 14. Now, the reason why
I beg your pardon, my sister. Are these documents in 69, for instance, in relation to paragraph 67 pertaining to Mr. Zuma matter? Because it seems to me, and Advocate Batohi can clarify, paragraph 67, 68 seem to relate to partly, I must say partly, to the Zuma matter. And that document that my sister refers to, AC 14, is it in relation to the Zuma matter? Because I asked, and I suppose my sister will guide us as to the relevance of these aspects, because the Zuma matters, if I remember from the opinion of Advocate Nalani, he advised that there be no referral in relation to all those matters, the Zuma matter, the Shongwa matter, and in other words, he confined his opinion to the Katomena and the Mdluli matter. And I'm not sure to what extent this document may be of relevance. Maybe my sister can maybe guide you in that regard.
Right. Thank you, Chair. The purpose of the questioning around these matters that were referred for opinion from Advocate Nalani, the importance of that to me is the time period to say, as at July 2021, when Advocate Nalani was briefed, he was briefed with the knowledge that the Karima complaint had been decided upon and Advocate Chauke had been exonerated. The Brown Hlongwa matter, Advocate Chauke had responded to the query, and by then you had full information of the response. And the Zuma matter, at the time when the Advocate Nalani was briefed, it was already known to the witness that the decision not to prosecute had been made by Advocate Galeka and another, that the decision of Advocate Chauke had been reviewed, that the matter had gone on trial and finalized. It's about the timelines to say, as at May, this information was there. And notwithstanding, the matters were nevertheless referred to Advocate Nalani for an opinion. That is the purpose of the questions. Thank you.
So am I to assume we are sort of looking at the appropriateness of my conduct in this process in terms of the steps that I took?
I am looking at the times as to what to make of that information is something that will be dealt with.
I'm just trying to understand so that I can answer properly whether there's any inference that I acted improperly, but I'll certainly try to explain it in the best way that I can. I certainly didn't have any intention of acting improperly in this matter, but I will explain as best that I can. So yes, this information was before me, and it's included in the brief to Advocate Nalani. Let me explain that, again, it must be understood the context within which I took office as the National Director. I was dealing with a period in the history of our country where we had allegations of state capture across government, including in the NPA. The Zondo Commission was doing its work, and there was a lot of information that suggested that people in the NPA were complicit in state capture. As a responsible national director, I wanted to make sure that I needed to understand whether there was any truth to those allegations or not, and in the event that there was, if there was appropriate action that a national director should take. So in these particular cases, but for Karima Brown, the other two persons involved, Brian Shlongwa and Duduzane Zuma, were very prominent persons. Brian Shlongwa, I think at the time, was the MEC for Health in Gauteng. And I should add, he is now facing those charges. So I needed to ensure that decisions taken were properly taken, notwithstanding the report that I got from Advocate Chauke. I wanted to go the extra mile and have these things properly checked out. So that is the reason why Advocate Nalane, and I'm casting my mind back to the time. I don't know if there was any other information before me at the time. I don't know. All I have are the documents in front of me now, and I'm trying to think about what could have prompted that decision. So that is the reason why they would have been included, is to make sure that all possible bases were covered. Well, I'm not sure it would have been all with Advocate Nalane's opinion, but certainly to add an extra layer of checking. And that is what I did. Of course, when his report came back, I didn't proceed any further with the 3 matters, but just the 2.
Advocate Nalane's opinion. Upon receipt of the opinion of Advocate Nalane, did you peruse the opinion and satisfy yourself as to whether it addressed all the information that you needed?
I certainly did peruse it at the time. There were clear gaps in his opinion at the time, which I think he himself mentions.
May I just request my sister to park that question or clarification? It's tea time. I propose that we take a tea break and return at 11:30. Biola Jen.